Welcome once again to my channel. My name is Msime Alex, and basically today we want to talk about one of the important topics in legal methods, and that is none other than doctrine of precedence. Most of people call it the doctrine of study, decisis. And basically, what we basically want to look at, how does it apply? What are the laws that have provided for it in the Ugandan laws? What is the effect of it, and actually how does it affect the judgment? Okay, that is very, very important. I also want to first I encourage you to subscribe, share with friends, and comment where necessary. What is the doctrine of stare decisis? The doctrine of stare decisis, this is basically a Latin maxim. Stare decisis is a Latin maxim, which principally means that being bound by the decided. That is what it means by study decisis. Then, of course, it is a replica of the doctrine of precedence. The doctrine of precedence is the effect that judicial officers or judges are bound to follow the decisions of the previous courts. Or this is where courts use decisions or apply decisions of the previous courts to adjudicate matters at hand. Of course, I will interest you in the definition is provided for still in the Black's-Law Dictionary, 9th edition by Brian A. Garner. He defines it very, very, very well. Look at it, it will give you an insight. Then, of course, you also have to look at the decision of Attorney General versus Uganda Law Society Constitutional Petition of 2006. It also talks about the same, the doctrine of precedence. And basically in that decision, court observed that under the doctrine of stare decisis or doctrine of precedence, which is the cardinal principle or a cardinal rule, that courts have the jurisdiction or courts have the duty to apply or to be bound or to adhere to the decisions of the previous courts. That's the brief of what the court observed in the case of Attorney General versus Uganda Law Society. It's a decision of 2006. Look at it and appreciate it. The doctrine has been provided for under our Ugandan laws. And basically, when you look at the 1995 Constitution of the Republic of Uganda, specifically under Article 134, clause 132. You look at Article 132, clause 4 of the 1995 Constitution of the Republic of Uganda as amended. It provides for the doctrine of precedence. And it is the effect that the Supreme Court, while treating its own judgments as normally binding, may depart from their own decisions when they deem it fit, and all other courts are bound to follow the decisions of the Supreme Court. That is the provision that brings it out very well under the Ugandan laws, under the grand norm of the Uganda. That is none other than the Constitution. That Supreme Court, while treating its own judgments as normally binding, may depart from their own decisions when they deem it or when it deems it fit. But it also says that all other courts are bound to follow the decisions of the Supreme Court. The effect of that is that Court of Appeal has the duty to follow decisions of the Supreme Court where applicable. High Court and all the other courts, they are bound to follow the decisions of the Supreme Court. Okay? That is very, very important for us to appreciate. We need to also look at different categories of precedents, different types of precedents that are applicable in the Ugandan laws or even other courts around the world. Number one, we have what we call the original precedents. Number two, we have what we call the binding precedents. And number three, we have what we call the persuasive precedents. Then the other one is, though not common, but it is called declaratory precedents. Okay? That is very, very important for us to appreciate. Let's now look at each in depth. Number one, we talked about original precedents. Original precedents, these are precedents which originate from cases that are decided they are actually first time precedents, that a judgment is delivered, applies a principle, or develops principle that has never been developed before. Those are original precedents. For example, when you look at the case of Susan Chigura, I know most of us have interfaced with this decision. This case brings it out a very good original precedent. It is one of the original precedents that we have at hand. It brings it out very well that it actually nullified the procedure of carrying out the death sentence. It has never been decided before. But from that decision of Susan Chigura, now it came up to into Ugandan laws, into Ugandan jurisprudence, that the procedure of carrying out death sentence being inhumane and actually being contrary to constitutional provisions, particularly Article 24, Article 28, Article 25, and different other provisions of the Constitution. It was declared null and void. The punishment is still provided for under the law, but the procedure of executing that sentence was declared null and void, thus making the decision of Susan Chigura an original precedent. We have different other decisions that have been declared, that have been decided on their first time, and thus developing principles. In short, the original precedent, these are precedents that have established new legal principles. Okay, that is very, very important. Then we have what we call binding precedents. Binding precedents, these are precedents that actually, this type of precedent operate basing on the hierarchy of courts. For example, as I earlier mentioned, when you look at Article 132 Clause 4, which talks about precedents basically on the side of Supreme Court, that Supreme Court decisions are binding on all other courts. That is what we call authoritative, rather binding. That is binding. Okay? Being binding means that you cannot cite a high court decision in the Supreme Court and you think it will be binding, but you can cite court of appeal decision in high court or Supreme Court decision in high court, and it shall be treated as a binding precedent. That is basically what it means. Okay. Then, of course, when we talk about that, I would love to bring a very good decision. When you look at the decision of there is the decision of Osotrako Limited versus Attorney General. We have a case of URA versus Peter. This case of on land acquisition. Those decisions of Supreme Court, if cited in High Court, they are binding, and courts must follow them. If they are not decided by incarium, that is very, very important. Please note, if a decision is cited by incarium we mean that a case or a decision was decided following a wrong principle or without applying the correct principle, then that decision will not be binding on the lower courts, because it lacked the basic principle of law, or it was decided on the wrong principle. Though it is binding, though it is from a higher court, but it was decided per incarium. Okay, that is very, very important. We have a lot of decisions. All decisions that were decided in the Supreme Court, as long as they applied, they developed very good principles. Not even very, very good principles, but they must be binding or in the lower courts. Please appreciate Article 132 Clause 4. I have to cite it again. It provides that Supreme Court, while treating its own decisions as binding, as normally binding, may depart from their own decisions when they feel it or when they deem it fit. Okay? But all the lower courts, all other courts are binding, shall be bound by the decisions of the Supreme Court. Okay? So look at look at it, and you will appreciate it the more. Okay? Of course, there you need to also move on and look at another type of precedents. One we call persuasive precedents. Okay? Persuasive precedents, these are basically precedents that are cited in court for purposes of persuading the presiding officer or the presiding judge or the presiding judicial officer. For example, when you cite a decision from a foreign court, for example, you are appearing in the High Court of Uganda, or you're appearing in the Supreme Court of Uganda, or you're appearing in the Court of Appeal of Uganda, and you cite a decision from Court of Appeal of Kenya, or you cite a decision from Court of Appeal of Zimbabwe, Court of Appeal of any other foreign court, that decision is not binding, that decision is not original, that decision is not authoritative, but it is basically meant for purposes of persuading the judge. Basically, in most cases, we have seen lawyers citing this decision, saying that I pray that this honorable court be persuaded by this decision from the foreign court. Mention any court that you want. So those courts, those decisions are just meant for persuading the judge. I mentioned decisions from foreign courts. I mentioned foreign courts. Look at Court of Kenya, look at the Supreme Court of Tanzania, look at Supreme Court of US. If cited in Ugandan courts, they are basically meant to persuade the judge, and not, they might be authoritative because they have principles, but they are meant to persuade. It's not a must that the judge will follow them. It's not a must that the judge will apply the principles developed therein, but it's basically to persuade. It is now on the discretion of the judge to either follow the principle or by the principle or set the principle aside. Okay, that is very, very important. Still, under doctrine, under the doctrine of precedents and persuasive precedent, you need to look at the obiter dicta from the Supreme Court. If an obiter of the Supreme Court is cited in High Court or Court of Appeal, it is not original, it's not authoritative, it's not binding, but basically it is meant to persuade. It is the council is calling the court to be persuaded by the obiter, to think together with the judge, maybe in a specific judgment, but under obiter, to be persuaded. Okay, look at it and appreciate it the more. Okay, so those different categories of precedents apply. Now we have what we call the declaratory precedents. Declaratory precedents, I think these are the most, to me, these are the most common things, or the most commonly precedents that we have been applying in courts. These are just the precedents which declare or apply the already established principle. Okay? The principle is already established, but again, the court is re-establishing it, or reaffirming it, or redeclaring it. Okay? That is what we call declaratory precedents. Okay? Another thing that we have to appreciate is the importance of precedents. Why is it important to apply these precedents? One, we need consistency of these legal principles. Consistency of these legal principles. The principle was stated, and as courts, we need to keep following that principle, unless otherwise. Please note, unless otherwise. We also need the certainty. Okay? That is one or two things that we need to always appreciate under the doctrine of precedents. Okay, of course, they also used by lawyers to advise their clients. These precedents are also used by lawyers to advise their clients. They are important. When you look at the decision and you feel like, okay, since this decision was applied by this court and this court reaffirmed this principle, then please, dear client, this and this must be in this regard. Okay? Of course, it also, as I talked about, we need to also ensure flexibility. Flexibility, we also, it brings in a room of change, the room for change. When you look at the judgment and you juxtapose it with another judgment, yes, you are trying to apply the doctrine of precedent. That's how they are applied. Judges will bring a precedent from a certain court, juxtapose it with the facts or with the case at hand to determine, does it apply? How is the law different? How has the situation changed? That is how things keep on changing, or that is how doctrine of precedence brings in the element of room for change. Okay? That is the most important part of it. But of course, you need to also appreciate the different disadvantages. Disadvantages, complexity, they usually bring in complexity. Okay? For example, it is not easy to find or to find a quick precedent to apply. Most of the facts are different from the facts before, and that's making it also hard to apply that principle or that precedent, because different cases, yes, we might apply the same law, but usually facts tend to be different. Okay? And of course, even once a case is found, the judgments are very complex and long. You look at the case of about 500 pages, and so it becomes hard to pick the exact principle to apply. Okay? But of course, as lawyers, as law students, you're meant to read. Don't use it as an disadvantage not to read cases. These are big cases. Please read them, pick out the principle, apply it, and those precedents will actually apply. Of course, maybe what I have not mentioned under advantages, it advances our legal reasoning. That is important. It advances our legal reasoning. Of course, that is much that we needed on doctrine of precedent. We try always to make things brief, to summarize what is basic, so that even when you watch this video, you go back and appreciate these principles the more. I told you I want to give a highlight as I conclude. Precedent is that these are basically a situation where judges are bound to follow decisions of the previous courts. We have about close to 4 categories. We have persuasive precedents, we have original precedents, we have and the binding precedents. I told you we have precedents that have established principles. We have the cases of like Donog versus Stevenson. Those are authoritative. Donog versus Stevenson, Curie versus Misa, Carril versus Carbolic Smoke Ball. When you look at the case of Carril versus Carbolic Smoke Ball, it established a principle. It is authoritative because it established a principle that of unilateral contracts. It didn't exist before. But from that decision, it was established that actually a person can make an offer to the general public or to more than 2 people, which do not basically need immediate acceptance, but by doing an act. When you look at the case of Donog versus Stevenson, it established the neighborhood principle that didn't exist before. Then Donog versus Stevenson is the effect that when doing anything, in whatever you're doing, you must ensure that your acts or omissions do not affect the neighbor. So those are what we call authoritative precedents, okay, or original precedents. You can actually call them authoritative stroke original because they established new principles. We talked about like persuasive. These are basically decisions from the foreign courts where decisions of courts at the same level. For example, High Court of Kampala will make a decision and High Court of Masaka will make the same decision, but it's not a must that they are binding, but they can be cited for purposes of persuading, like that. Then also we talked about obiter from the Supreme Court, from all higher court of higher court in the chain. So that such obiter can be cited for purposes of persuading the honorable judge. Then we talked about binding precedent. Binding precedent, we cited Article 132 of the Constitution. It basically brings it out very well, or as far as the Supreme Court decisions are concerned, and also brings it out again that the lower courts must be bound by the decisions of the Supreme Court. Those are in summary, of course, the different categories of precedents. I wish to thank you so much for watching. Please subscribe to this channel, share with friends, and remember to always comment where necessary. We always request for your comments because we don't know whether you need clarity or what. But when you read your comment, we get to understand that you actually need clarity. Thank you so much. May God bless you.